All right, this is case 2133, Macomb County Restaurant, Bar, and Banquet Association, a Michigan nonprofit corporation versus Elizabeth Hertel in her official capacity as Director of the Department of Health and Human Services, Pat Gagliardi as Chair of the Michigan Liquor Control Commission, and Gretchen Whitmer in her official capacity as Governor of the state of Michigan.
Yes, ma'am. I will start promoting and bringing in the council. Just one moment, please.
Ms. Mua, and okay, we just want to see everybody's face if we can. Council, if you would state your appearances for the record, beginning with the plaintiff's counsel.
Good morning, Your Honor. Sean Kelly on behalf of the plaintiff, the Macomb County Restaurant, Bar, and Banquet Association.
That was a good beginning.
Good morning, Judge. Darren Fowler from the Attorney General's office on behalf of defendants.
My understanding is we have two other counsel present. Do you wish to state your appearances, please?
Good morning. This is Assistant Attorney General Andrea Mua, also on behalf of the defendants.
Mr. Addis? Mr. Addis, are you with us? Well, I do understand who's arguing. I just need to understand. I assume Mr. Addis does not wish to place his appearance on the record. If he does not, we could allow him to return to observers, I guess, because it's a little awkward to have this blank space. This is the motion for summary disposition hearing filed by the state of Michigan defendants collectively. The court has received the papers and pleadings of the parties. On behalf, my understanding is that it is Mr. Fowler who is going to argue. Is that correct, Ms. Mua?
Yes, it is, Judge.
Okay. Mr. Fowler, if you could address your motion, please.
Thank you, Judge. Judge, through their constitution, the people of the state of Michigan have made abundantly clear that the public health is the matter of primary public concern. The defendants in this action are the governor and officials who have taken steps to try to protect the people of Michigan from the deadliest pandemic that has hit the United States in more than a century. The plaintiff in this lawsuit is a restaurant association in Macomb County that was formed earlier this year, apparently for the purpose of bringing this lawsuit. The plaintiff, in its complaint and in its filings to this court in relation to motions, has made very clear that the only relief that it is asking for through this lawsuit are the money damages that its restaurant members allegedly incurred during the pandemic. The association is not seeking any kind of declaratory relief or other relief from this court. The party does not have standing to do this. We have in our response brief in support of our motion, Judge, brought to this court's attention the United States Supreme Court's decision in Worth versus Selden. In that case, there was a home builders association that tried to do precisely what the restaurant association is attempting to do in this case, get money damages that, if they belong to anybody at all, would belong to somebody other than the plaintiff in the action. Now, Judge, I know you know, obviously, that the state of Michigan courts do not usually follow federal precedent on standing concepts, when it is tied to the case and controversy requirement. I want to point out that Worth versus Selden is a case where the United States Supreme Court was speaking to standing more broadly than just the case or controversy requirement. The court was very specific in explaining that it was also looking at justiciability concerns. And specifically, that kind of concern remains very vibrant in Michigan, that a party who is coming to the court asking for relief has to be the party that would be entitled to the relief if it were actually going to be granted in a case. Now, the Restaurant Association does not have standing, but it also hasn't presented any kind of claim in this lawsuit upon which relief could even be granted. The primary claim that the plaintiff is making is one for a taking under the Michigan Constitution. But no taking has occurred here, Judge. What we have in this case is a situation where officials have issued orders to try to protect the public health of Michiganders. Again, pursuant to another constitutional directive that the people have given. We have supplied for the court's benefit numerous cases, both from the United States Supreme Court and in Michigan, showing how the taking doctrine works and does not work in the context of a public health activity such as is going on here. I want to highlight.
Caller, if I may, your colleague suggests that while they disagree with the actions of the Department of Health and Human Services, that the actions of the governor for a period of time have been declared ultra vires, and that if they have standing, they have the ability to assert that however well-meaning, the governor acted without authority, and that that action for that period of time is one for which damages may be recovered by an appropriate entity. Could you directly address that?
Certainly, Judge, with two concepts. First, in issuing that certified opinion decision last October, the Michigan Supreme Court emphasized that it was saying that the director's actions going forward could not happen under that statute. The state Supreme Court said nothing that would suggest that the activities the governor took retroactively were in any way invalidated. When the governor was acting last year up until the time of the certified question decision, she was doing so pursuant to a statute that was on our books. It was a valid statute. Now, that leads to the other response. In their response brief, Macomb County Restaurant Association argues that takings does apply if there has not been valid legislation to which actions have been taken under. That is, they have pulled a small quote out of the United States Supreme Court's decision in Keystone from a century ago to try to make that point, but they took it out of context from the case in which it arose. The Keystone opinion makes very clear that it's not whether an action was taken under valid legislation, it's the purpose for which action has been taken that is the controlling consideration. And regardless of what may have been said by the Supreme Court about the statute under which Governor Whitmer acted last year, what is clear to everyone is that her purpose in doing it was to protect Michiganders from this deadly virus. So then continuing, Judge, the plaintiff here has presented absolutely no case law that supports its view of what a taking should be in the context of this case. They try to distinguish Keystone and other cases. They present none of their own that say that in this context that a taking has occurred. We have pointed to cases throughout the country where courts have rejected the concept of taking within the context of this pandemic for very obvious reasons, that this is an action taken under the police power to protect the public health. A case worth noting is the National Amusements versus Palmyra case out of the Third Circuit. There is a situation where the court was confronted with a flea market that was where the operator sued. The flea market was closed by the Palmyra officials for a period of time because there was concern that there were unexploded ammunitions on the premises. The court there very quickly dispensed with the taking claim, pointing out that no doubt, the court said we can't imagine anything more important to protecting the public health than making sure there's not unexploded ammunitions in this place where the public are going to be walking around. There was no Penn Central analysis and no need for it. There was no need to develop a record in that case beyond for a taking to understand that concept. It was to protect the public health. And the theme is true here and even more so, Judge. The effects of this epidemic in Michigan are everywhere. It's not limited to the grounds of a flea market. The plaintiffs' other claims in this action then are brought under tort theories. And we have pointed out in our briefs that the defendants here have immunity against those types of claims.
Okay. I think I understand your argument, sir. In response.
Thank you, Your Honors. First, I'd like to point out and address each of Mr. Fowler's arguments in turn. So he mentions the deadliest pandemic, but 99.6% of people survived this virus. And more importantly, and more to the point, with respect to our restaurants, in and of themselves, only 2 to 4% of all positive COVID cases are attributable to our restaurants, Judge. And as far as the argument that we're only seeking money damages, well, of course, that's correct. But we do have standing. I think that this is by far state defendant's weakest argument.
Counsel,
Standing.
what you pointed out in your brief was that a not-for-profit association, or frankly, a profit association, does have the ability to advocate for policy on behalf of its members. Share with me where I should look to see that a not-for-profit association or a for-profit association may seek monetary damages on behalf of individual members, where the damages will clearly be different as to each, as opposed to either filing and seeking certification as a class or taking other procedural avenues available under the laws of the state of Michigan.
So to answer that, Judge, there is a few cases, Blue Cross and Blue Shield of Michigan versus Milliken is a case where, in fact, the Michigan Supreme Court ignored the challenge completely because standing is in and of itself a prudential doctrine and not a legal doctrine. The court, regardless of the remedy sought, Judge, can allow and confer standing on a litigant. Auto Club Insurance Association versus Frederick and Herod Inc. That's a 1993 Michigan Supreme Court case. This was the same reason here. Essentially, the court ignored the standing doctrine completely for public policy reasons. There's a long line of case law where they talk about courts.
And let me work with me on this a bit. In either of those cases, was the relief sought monetary? I don't recall it was, but I could be wrong.
I believe in Blue Cross and Blue Shield of Michigan, it was, Judge. That's a case where the shareholders had brought an action.
Shareholders.
That BCBSM had brought an action on behalf of the shareholders. Correct. I apologize for that.
And a share and an action on behalf of shareholders is in essence seeking damage on behalf of the corporation, which owes to its shareholders a dividend. I'm not seeing the similarity. So focus my attention on why it is similar and why it isn't in essence an action, a circumstance where there was a public policy issue where Blue Cross was saying, state of Michigan, you have done these things that inure to our detriment. We need for you to stop. And this detriment has cost us as an entity, a corporate entity, a damage, as opposed to, in your case, where you have individual members who each have a different profit and loss circumstance and situation.
I see. I think I understand your question, Judge. To that point, there is a mild amount of distinguishability between, say, Blue Cross Blue Shield and the case here. However, it is analogous in the sense that those shareholders and the organization had this sort of symbiotic relationship wherein the organization brought suit on behalf of those members. Same thing is true here, Judge.
What is the symbiosis between Joe's Crab Shack, a fine restaurant, and Macomb? Why are they the same? One is a member.
Correct. So
who
as
does really well, and then you have Mrs. Smith's breakfast joint, where everybody goes in downtown Mount Clemens. Mrs. Smith was making enough to make sure she kept her restaurant open and is now, unfortunately, quite likely out of business. Her annual profit was, ignoring the IRS code, maybe 1%. Joe's Crab Shack, a franchise, has a profit of 15% and it's related to its revenues. Tell me the symbiosis between the two. Joe's Crab Shack is open from noon to midnight or 2 o'clock on a Saturday night. The diner is open from 6 to 1 because it's a breakfast joint. Help me understand. I mean, I think the damages in this case are complex and they do concern me. And it does feel, if there is standing, if there is a takings claim to be made, that it's a class action. It doesn't feel to me like something for which an association can make adequate advocacy and seek the relief that you're asking this court for.
Understood. The symbiotic relationship, and I think we may be talking about two different things here. The symbiosis that I'm referring to is one that between the association and its members, and that's where we see this associational or organizational standing doctrine come to fruition, right? It's the relationship between the members and the organization that's suing on their behalf, whether or not those members can survive without the association or vice versa. Here, the association cannot survive without its members. And if the regulation—
But it's not true the other way around.
And it need not necessarily be, Your Honor. It's the matter
Well, symbiosis requires a mutuality.
to
Relationship is different. Symbiosis means the host cannot survive without the member. The member cannot survive without the host. That's truly, the association only exists because of its members. There is no question. But I don't know that there is that kind of mutuality.
So maybe a bad word to use. I would say more that, say, the members are the vital organs of the body, if you will, right? And so the organization itself cannot survive without these members. And if these members go away because of the regulations, then that's that. If you look at the case that defendants cite, which is Warth v. Selden, it opens up an avenue whereby, and this is forgetting the fact that Your Honor, you can at any time ignore the doctrine of standing if you wanted to anyway, because again, it is not a legal doctrine, it's a prudential one. But looking at that Worth v. Selden, it allows members to assign their rights to the claims of damages and collection of damages for the purposes of these types of cases. So if
Well,
that's
okay, that takes us back to, we've been living lately with the whole problem of individuals who have automobile accidents and how they assign their rights to their providers to recover against the entity or the individual who they think has damaged them. And you can agree with me that that's been kind of a mess, and that our requirement for assignment has been really pretty specific in Michigan. It can't be just because I came to John Smith, the fine chiropractor, that the chiropractor can sue on my behalf. I have to specifically do an assignment of a particular kind. My understanding from what I saw in your papers, and I don't know your organizational structure, but it is one where your members have joined and asked you to represent their interest. I do not know that they've assigned their interest to you, have they?
They have not. I'm merely offering that, Judge, and if it is necessary to do so, if you find that it's required, that could streamline it. But as to your larger point, this actually, the fact that we're bringing it in this manner on behalf of the organization, on behalf of its members, actually streamlines, the litigation, because unlike auto, where you assign to all these different providers and now they can sue in their own right, and of course that creates all these different cases. Here we have one case.
Well, it's probably efficient. I don't know if it's legal, but it's efficient.
Again, Judge, it's a prudential doctrine and not a legal one. And the Michigan courts have routinely ignored the standing doctrine for public policy reasons and for a number of different
Well,
reasons.
actually, they've not done it routinely. They have infrequently done it, but it has occurred over a period of years. Standing is pretty much followed in most cases. The ones you addressed are rare, and they were rare, and the court chose to not address standing because of the nature of the interest. I don't disagree that we can. I routinely, no, not at all.
Well, and this is a rare case, Judge, to your point. And again, this is the defendant's motion, and they've actually cited no binding Michigan case precedent wherein there is some law that abrogates or in any way derogates Lansing School Education Association versus Lansing Board of Ed, which is a 2010 Michigan Supreme Court case. And I'll quote from it: under Michigan law, an organization has standing to advocate for the interests of its members if the members themselves have a sufficient interest. Our members do.
I know you have more.
Oh, I didn't know if you wanted me to move on from that. I was waiting. Okay. So, as to the point, and Mr. Fowler said this, no taking has occurred. And he's looking at this police power doctrine. That's not true. Even if you follow the jurisprudence that is cited by defendants, that's not actually what the case law says. It never says that takings don't occur. I mean, takings, just as a factual matter, occur. It's whether or not those takings are compensable. So I want to make sure that that's a finer point, and I'll move on from that. But I thought that was an important distinction to make. As far as the issues of what in-res certified questions rule going forward with the governor's constitutionality of her orders, et cetera, that it wasn't retroactive in those types of things. In-res certified questions ruled unconstitutional, the Emergency Powers of Governors Act. An unconstitutional law is void, not voidable, not maybe sort of void, meaning it was never in effect from its inception. And therefore, we're arguing that very clearly. Anything that the governor did under that law was completely illegal from the beginning. Defendants talked about valid legislation and how they believe that we misrepresented Keystone bituminous. Keystone's reasoning was adopted in part by Michigan case law in the cases that we both sides cite this case in the briefs. And so that's a very important part of it, actually. I mean, we cannot have by fiat orders willy-nilly by any unelected or even appointed officials. And so that kind of stuff, again, the valid legislation and whether or not a police power was properly invoked by the state, this is a very important point. That is only one part of one factor in the Penn Central analysis. We're under the Penn Central factors here for a temporary regulatory taking. And so the police power really only goes to the nature of the government's action, right? Penn Central has three factors: the character of the government's action, the economic effect on the regulation, the economic effect of the regulation on the property, and the extent by which the regulation has interfered with distinct investment-backed expectations. They talk about cases pointed to throughout the country. One of these was the Third Circuit case about unexploded ammunition. That is a completely different in-kind situation than what we have here. That's a concrete attribute of the premises itself in that case, whereas it's not what we have here at all with respect to restaurants, bars, and banquet halls. 2 to 4% of all positive COVID cases are attributable to restaurants, but it's not something that's inherent to the property itself. And that's an extremely small situation in the grand scheme of all the other regulations that have been put out there with respect to all sorts of different kinds of properties and property owners. I just want to run through and make sure I've got everything here.
Well, the fact that you don't say it out loud doesn't mean you didn't write it. So you need not necessarily address everything that you addressed in your well-written pleadings and papers.
Thank you, Your Honor. I want to make sure that we're clear about what the nature of at least the takings claim is here with respect to defendant's motion. This is a C8 motion. It's not a C10. And so defendants have come here and said, you know, we don't need factual analysis whatsoever. There's no way that the plaintiff can ever overcome with what they've pleaded the police power. It's simply not true, Judge. Under the Penn Central factors, it's very clear that you have to run through an analysis of all this. And the police power, again, is only one part of one of those factors. None of those factors are dispositive at all, despite the defense attempt to make it appear that way. Okay, so when they're saying that there's no factual analysis needed and that we can't present facts before discovery in order to determine whether or not a regulatory taking has occurred here and whether or not police power.
Mr. Kelly, you're talking way too fast. I can't keep up with you. Please slow down.
I apologize.
When they say there's no factual analysis, meaning, would you slow down, please, and talk slow?
I will do. I apologize. I have a habit of doing that. You're not the first court reporter to tell me to slow down.
And even as you responded to her, you raced through the answer. So
Understood.
breathe.
Will do.
So I said, when they say there's no factual analysis, meaning go from there.
Necessary in this case to dispose of our case, that's simply untrue because the Penn Central factors demand a factual analysis. In essence, what defendants are arguing here is a C10 motion, but they haven't brought that. Okay, Penn Central is controlling here, and both parties have cited the case K&K Construction, which is a 2005 Michigan Court of Appeals case. And Penn Central is the 1978 US Supreme Court case that was adopted into K&K. This requires an ad hoc factual inquiry. That's not what is at issue here as far as their C8 motion with respect to takings, Judge. This necessitates discovery. And so defendant's motion, again, might be viable if it had been a C10 motion, but it's not. Here, the court, under the C8 motion, must take plaintiff's pleaded facts and allegations as true. Again, police power is only one factor. The public interest is of importance here as well. The public interest must be weighed against the private interest in these types of cases, Judge, even when a private interest constitutes a nuisance. I know that defendants' briefs talked about nuisance abatement and police power and those types of things. And we all understand that a taking of a nuisance property is a lot of the time found not to be a compensable taking. But in some instances, even then it is. And we don't have that here. And that's from Keystone Bituminous. What the government intended is irrelevant. The sufficiency of the state's justification for action is relevant. We need discovery to determine exactly
Mr.
what.
Kelly, Mr. Kelly, you're speeding up again.
I apologize. I will slow down
We'll
even.
get through this quicker if you slow down, and I won't have to interrupt you. The sufficiency of what?
Of the state's justification for their regulatory actions is relevant. We need to know, Judge, how, when, where, and why the state made their determinations for regulation. Over 3,000 restaurants have closed permanently in the state of Michigan out of 17,000 food service licensees. That's 1/5 of all food service establishments in this state are closed forever, permanently, final. Yet only 2 to 4% of all positive cases of COVID are attributable to these food service establishments. The defendants never point to any binding Michigan case law whatsoever that says that the police power itself in pandemics makes takings non-compensable. They have none, no binding case law in Michigan at all, Judge. And
I think I understand your argument, Mr. Kelly.
thank you, Judge.
Is there anything that you feel compelled to share, Mr. Fowler, that you have not previously addressed or written?
No, Judge, thank you very much for your time this morning.
Okay. Thank you both for your argument. I will endeavor to get you a ruling on this motion within 14 days. Part of that will depend upon Ms. Roberts' ability to give me a transcript, and I know she'll work at that as fast as she can. And we'll attempt to, again, between 14 and 21 days at the least. Thank you very much, and we will be adjourned.
Thank you.
Thank you, Judge.